Committee on Business Professions and Economic Development. For our hearing today, we have 12 bills on our file. However, file item number 8, SB 1217 by Senator Stone, has been put over till next week. There are 2 bills proposed for the consent today, file items 2 and 10. We'll establish a quorum and then we'll vote on the consent calendar. Please call the roll.
Hill.
Here.
Hill here. Bates.
Here.
Bates here. Berryhill.
Here.
Berryhill here. Block. Block here. Galgiani. Hernandez. Jackson. Mendoza. Wachowski.
Here.
Wachowski here.
Very good. We do have a quorum. And
I'll move the consent
we have a
calendar.
motion from Senator Wachowski on the consent calendar, which is item number 2 and item number 10. Please call the roll.
Hill.
Aye.
Hill I. Bates.
Aye.
Bates I. Berryhill.
Aye.
Berryhill I. Block.
Aye.
Block I. Galgiani. Hernandez. Jackson. Mendoza. Wachowski.
Aye.
Wachowski I.
Very good. We have 5-0 on that. We'll hold the roll open for the absent members. Thank you, Senator Bates, for accommodating us this afternoon. Have a safe flight.
I wish you luck. I didn't bother. It's not going to be fun. All right, we'll start off, Senator Hill, with your presentation. And if we can get some witnesses in support, or are you it?
No, there are some.
I figured as much.
No one in opposition, I believe. Okay. Good afternoon, Mr. Chair and members. The policy question before us is, should patients be notified prior to their appointment if their physician is on probation by the medical board for serious offenses such as sexual misconduct, substance abuse, gross negligence, or a felony conviction related to patient care? There are over 137,000 licensed physicians in this state. This bill only applies to about 500 to 600 of them who underwent an extensive 2-year investigation and probation procedure involving several state departments. Misconduct cases undergo rigorous scrutiny by multiple state entities and are not taken lightly. The medical board's expert physicians review cases to determine if they have merit. They are investigated by Department of Consumer Affairs specialists and reviewed by the State Attorney General's office for the filing of a charge document called an accusation. The case then goes to a hearing before an administrative law judge. If the physician disputes the accusation, it goes before the administrative law judge. Ultimately, the outcome of the hearing or of an undisputed case is decided by the medical board, which determines whether to accept findings and impose discipline. Discipline could range from a letter of reprimand, probation with specified terms and conditions, or license revocation. Physicians are already required to inform hospitals and malpractice insurers of their probation status, but their patients, the most important people in the healthcare continuum, have to seek out the information for themselves. Patients deserve to be notified prior to their visit if their physician is on probation for serious offenses such as sexual misconduct, substance abuse, gross negligence, or a felony conviction related to patient care and treatment. Here are a few examples of doctors currently on probation that would be required to notify their patients if this bill were in effect. Dr. Van Vu runs the California Pain Center in Huntington Beach. In recent years, 16 of his patients have died from drug overdoses. He was accused of gross negligence and placed on probation by the medical board after an exhaustive investigation. An orthopedist was found to have committed gross negligence in the care of 2 patients, including one whose fractured thigh bone was incorrectly treated for 2 months, allowing the sharp end of the bone to erode through the skin, resulting in the patient's leg having to be amputated. The doctor is currently serving 3 years probation. A urologist was found to be excessively using alcohol following a DUI arrest on a weekend when he was on call for a local hospital. 5 months later, he admitted to drinking again while on call. He is currently serving 4 years probation. A neurologist was found to have allowed unlicensed medical assistants to routinely give patients narcotic painkillers through infusion pumps, and in one case, a woman was sent home after receiving more than 4 times the proper dose. She was found dead the next morning. This doctor is currently serving 5 years probation. A family practice doctor was found to be excessively prescribing controlled substances to patients, including one who received over 1,000 oxycodone tablets at one time, and another who filled prescriptions for more than 41,000 methadone tablets over a 28-month period. They also sold drugs for cash without labels, patient names, or adequate records, and provided free drugs to patients in exchange for sex. This doctor is currently serving 10 years probation. An orthopedic surgeon, while on probation for substance abuse and forging prescriptions for highly addictive drugs in fictitious patients, was caught using a prosthetic penis and bladder to circumvent urine testing as part of mandated drug testing. He is currently serving 5 years probation. And a pediatrician was charged with sexual misconduct for coercing mothers of his patients to allow him to examine their feet while in the office. During one exam, he took the patient's mother's right foot and placed it on his inner thigh, then began rotating the foot so that her toes rubbed against his penis. He later said that he had engaged in similar conduct with 30 or more female patients over a 12-month period. He's currently serving 9 years probation. A primary care physician was found to have ordered more than 4 million tablets of prescription painkillers containing hydrocodone over a 15-month period. But investigators from Drug Enforcement Agency could account for only 167,000 tablets. She is currently serving 7 years probation. A cardiologist was found to have performed gross negligence in treating 4 people with heart disease. Now just think about that, 4 people with heart disease, including 2 who died. He was cited for exposing a patient to extremely excessive radiation, failing to order appropriate follow-up tests, dictating a fictitious history and physical without seeing a patient, and dictating medical records weeks after a patient's death. He is currently serving 5 years probation. Now, 82% of Americans think that patients deserve to know if their doctor is on probation for serious offenses. And several California newspapers agree. The LA Times editorial board wrote, "It's awkward, no doubt, for a doctor to inform patients when he or she is on probation." The California Medical Association predictably objects to notification, saying it would, quote, "put a burden on the doctor-patient relationship." True, but that's the very point. Patients should be fully informed so that they can decide whether they want that relationship to continue. The Contra Costa Times and Oakland Tribune editorial board stated, quote, "The California Medical Board should stop shielding bad doctors and instead require that those on probation tell their patients." But the president of the board made clear that he has no intention of making the change. Instead, he only wants to tweak the agency's website. Another LA Times editorial stated, "If the medical board is unwilling to force wrongdoing doctors to inform their patients, then the state legislature ought to step in. The inconvenience and discomfort of a small percentage of physicians must not trump what's in the best interest of patients." And the San Jose Mercury News editorial board wrote, "Lawmakers need to put the public good ahead of special interests and require disclosure." Thank you for indulging me in this, and there are witnesses in support, Mr. Chair.
Thank you. Your witnesses?
Good afternoon. My name is Lisa McGifford. I am the director of the Consumers Union Safe Patient Project, and we are the advocacy arm of Consumer Reports. And the cover of the current cover story of the current Consumer Reports article looked at many of the doctors that you've heard of here today. And one of the things that we were looking at was that there were these cases where there was serious offenses involved, and yet these doctors were still allowed to practice and see patients. They are under the board's monitor, but they do not have to tell their patients about this probation order. And we think those patients should have that information when they see this doctor. There is information on the medical board website, but it's very challenging for people to work their way through the website, to find the information, to read the documents, et cetera. So it's really key that the small fraction of doctors that fall under this this legislation, be required to inform those patients. Some people say that this is very disruptive to the patient-doctor relationship, that it might harm that trust between the doctor and the patient. But there is no greater violation of trust if a patient is harmed by a doctor who's already on probation for the very things that happen to harm this patient. That is like such a violation of trust. We think that patients should be informed, that they have a right to know, and that they should make their own decisions on whether to see the doctor. And some of them will continue to see those doctors, and some of them might choose not to continue to see those doctors. It is a burden on the doctors to have to say to their patients that this is happening, that they are on probation. But it's even more of a burden on patients if they are harmed. It can change their whole life. And that's why it's important for, it trumps the burden on the doctor. And the burden should not be on the patients to have to dig this out and look it up. They should get this information directly from the source. Thank you.
Thank you.
Good afternoon. My name is Michelle Montserrat Ramos. I'm with Consumers Union Safe Patient Project. I became a patient advocate following the death of my fiance, Lloyd Montserrat. Lloyd Montserrat was a political leader. Here's Lloyd in life. Like you and I, he believed that he would be safe in a hospital and that our regulatory boards, whose mission it was to protect consumers, would regulate and monitor its doctors with our best interests in mind. Lloyd was a vote director for the Democratic Congressional Campaign Committee, the DCCC, a director for the National Association of Latino Elected and Appointed Officials, NALEO, a chief of staff for a Los Angeles City Council member, and a well-respected political consultant. Following his graduation from UCLA, Lloyd even organized nurses for SEIU Local 660 out of LA County USC Medical Center. Before Lloyd entered the hospital, I went to the medical board's website to look into Lloyd's doctor's background. When I checked the medical board website, Lloyd's doctor's profile was clean. It gave me a false sense of security that I had done the right thing by him. In fact, Lloyd's doctor's background was far from clean. There were no arrests listed, and Lloyd's doctor had been arrested various times, including for felony possession of crack cocaine. There were no malpractice judgments, and the medical board knew of 3, as a judgment was listed on his doctor's profile 6 months after Lloyd died. There was information that the medical board had knowledge of, but it was not available to Lloyd or I, and I believe it played a contributing factor in Lloyd's death at the age of 36. In Lloyd's case, the problem was that Lloyd's doctor had a substance abuse problem, a problem with crack cocaine. At the time, I was not aware of a confidential physician diversion program that had been in existence for 27 years. Doctors with substance abuse problems were allowed to continue practicing, participate in this program, and could do so under complete confidentiality, with their patients not having the right to know that their doctors were in the program and were substance abusers. When the program was abolished in 2007, those doctors were moved to the probation program. Today, you will find a significant number of substance abusing doctors who are on probation. Now, with the confidential diversion program abolished, the information about one's doctor's substance abuse problems can be found on the medical board website, if you know how to find it. You see, the medical board believes that the doctors on probation are safe to practice. I disagree, and I believe that most Californians would agree with me. Doctors on probation are not only substance abusers, some have sexually abused their patients, some have overprescribed narcotics, with some writing fictitious prescriptions for their own use, and a number have been found to have been grossly negligent with the care of their patients. All of these issues directly impacts patient care and would be something that you would want to know about your doctor before you put your life or the life of your loved ones in their hands. The medical board believes that it's the patient's responsibility to locate their doctor's background information, such as their probation orders, on the medical board website. Not only is the information difficult to find and not presented in a patient-friendly manner, those patients who need the information the most, the chronically ill, for example, dialysis patients, Dialysis patients are the biggest consumers of our healthcare system. They are required to see more doctors, they are hospitalized more, and they have more surgical procedures. They need this information. Many of the chronically ill are not able to maintain internet access or maintain computers because they must make hard life decisions daily. Are they going to pay for necessary medication that's quadrupled in price, or are they going to maintain internet access? These are the patients I am asking you to keep in mind when you vote today. I urge you to vote yes on SB 1033. Thank you.
Thank you.
Good afternoon. My name is Tina Manassian. I'm a survivor and a victim of medical harm. My doctor had a chronic history of alcohol abuse, and it was a participant of the Medical Board of California's defunct diversion program, a confidential program. I wasn't the only victim. There are countless others that suffered and have died. In 2002, Dr. Brian West performed a surgery on me that I was not a candidate for. After the surgery, he cut me back open and left me open, bleeding, and infected. A few months later, he closed his practice down and abandoned me. Nearly 14 years after my botched surgery, I still suffer from excruciating pain. Spitting sutures, gaping holes, disfigurement, and a mutilated body. I will be forever reminded of the harm this doctor caused me. His license was revoked 7 years after my surgery. Although this happened many years ago to me, under the existing medical board program, a physician like this would likely be on probation. So if this bill were passed, I would have been informed, and I wouldn't have chosen him. So SB 1033 provides me and Californians the information we need to make an informed decision on who we want and do not want to treat us. This bill will require the medical board to mandate physicians to inform their patients of their probationary status. We're talking about nearly 500 California doctors on probation for serious offenses. Number 1, repeated acts of gross negligence. 2, sexual misconduct. 3, repeated acts of overprescribing of controlled substances. 4, drug or alcohol abuse. And 5, felony convictions arising from or occurring during patient care or treatment. The medical board requires doctors on probation to inform the hospitals where they practice and their malpractice insurance companies, but not their patients. This is an outrage. It's an absolute outrage. The paramount priority of the Medical Board of California is and should be patient protection, not protecting doctors. We're talking about people's lives and health, your family, my family, Californian families. State law already requires the medical board to post on its website information about physicians on probation. However, to find a doctor on probation on the medical board's website is nearly impossible. It's very difficult, it's frustrating, and it's time-consuming. SB 1033 would require that the medical board prepare and make available a standardized plain language summary that describes, among other things, the offenses that led to the physician's probation. SB 1033's requirement that physicians disclose their probationary status directly to their patients is particularly important because not everyone has access to the internet, and some don't even use it. We're talking about serious offenders, and patients have the right to know. I urge you to support this bill. Thank you for your consideration.
Thank you. Do we have witnesses in opposition to this bill?
More support.
Oh, is there other support? Excuse me. I imagine there is a few out there.
Good afternoon, Mr. Chairman, members. Ed Howard, Senior Counsel with the Center for Public Interest Law. I just wanted briefly to highlight 2 quick points. The first is on page 6 of your analysis. The analysis makes clear that the California Research Bureau exhaustively studied the question of physician discipline and whether or not a physician who had been previously disciplined was likely to do something in the future that would also result in discipline, and the answer was yes. To quote from the CRB, again quoting from your analysis, quote, "These findings strongly imply that disciplinary histories provide patients with important information about the likely qualities of different physicians." And you read the rest of the analysis, that section, and it makes it clear that what we're looking at is potentially a 30% greater likelihood of physicians who have been disciplined in the past with potentially being disciplined in the future as compared to physicians who haven't been. And that, by the way, the predictive reasons why past physician misconduct forecasts future physician misconduct, that's exactly the reason why insurance companies and why hospitals insist upon getting this information and why patients should get it as well. We respectfully ask for your eye vote. Thank you.
Mr. Chair and members, Monica Miller, Sacramento Advisors, representing the California Chiropractic Association in support. Thank you.
Hello, my name is Marion Hollingsworth. I'm from La Mesa, California, and I support SB 1033. Thank you.
Hello, I'm Dr. Julie Elginer, and I'm representing the California Chiropractic Board. So we are also a board that is responsible for the oversight of the chiropractic profession. I just want to share a few quick points with you because I believe we are one of the only boards that may be here representing the administrative components of the oversight of probation. I also want to let you know that the process by which chiropractors go through an evaluation is very similar to what Senator Hill described. So it's very analogous to the chiropractic profession. I just want to start quickly. Professionally, I am a faculty at the UCLA School of Public Health. I hold appointments in 2 different departments, so I'm a public member of the board of chiropractic. I am not a licensed member, but I do have licensed members with me in support, as well as our executive officer. So I want to just share with you that the enforcement committee for the chiropractic board has considered promulgating regulations over the last couple of years, and we strongly believe that a legislative mandate would be preferred, and so we are in support of this piece of legislation. There's 4 main points that I want to address. The first is that we believe that SB 1033 increases the health and safety of the disadvantaged communities, such as the elderly, youth, and the poor. Numerous studies have proven these historically disadvantaged communities are less likely to have access to the internet and are much more likely to have lower health literacy, making it extremely difficult for them to manage their health care. And this would make it much easier for those disadvantaged communities to receive and to understand probationary information. Second, we believe that it removes barriers to disciplinary information. When a patient is seeking health care, they should not have to jump through hoops to find out whether their provider, their doctor, is on probation. Third, it will likely result in increased safety for patients by ensuring that patients are informed regarding a licensee's probation. It's going to enable those patients to make their informed decisions, as we heard. And lastly, and this speaks to the rehabilitative process, I just want to make sure that you understand that the chiropractic board believes that this is not a punitive measure. In fact, it's a rehabilitative measure. And so we strongly support this as an educational tool to equip patients to make informed decisions about their health care. We see this as an opportunity for the licensees themselves to begin the process of rehabilitation and hopes that they complete the probationary process. And ultimately, we believe through this process that they will become a better practitioner for those people that they took the oath to protect. Okay? And then lastly, I just want to share a couple things. Specifically, we firmly believe that the disclosure process does not add any more of a burden to the business as informed consent or HIPAA privacy laws or anything else that healthcare providers are required already to disclose as part of the engagement process. So lastly, we are in strong support of this bill. We ask for your aye vote. Thank you.
Thank you, and please be brief as you do your support for this bill.
Thank you, Chairman. Thank you, Chairman Hill and committee members. My name is Renee Nielsen. I am just a regular community member here representing 38 million Californians. And I'm a single mom with 2 kids, and we feel like that it's a no-brainer that we would love that this information was already enacted and available to us. So I'm in support. Thank you.
Great, thank you.
Hello, Senator Hill and everyone. I want to thank you so much. My name is Carol Moss. I'm with Niles Project, and I'm here also with Consumer Reports Safe Patient Project. We are in favor of this legislation, and we thank you. I thank God for this. We know many people that have been harmed, and we are in favor of 1033. Thank you.
Thank you.
My name is Ty Moss. I'm a co-founder of Niles Project as well, and we are 100% in favor of 1033. Thank you.
Thank you, Mr. Chair and members. Megan Brightwell on behalf of the Consumer Attorneys of California. Pleased to be in support.
Thank you. My name is Jack French. I'm a hospital-acquired infection survivor, and I'm in support of 1033. Thank you, Mr. Hill.
Thank you.
Good afternoon. Magna Carta. I'm the third Elizabethan by birthright. My birth name is Phyllis Anita Helms. I'm in support. I had a bilateral mastectomy. I was diagnosed with Big C. While I was under anesthetic, I was sexually assaulted and abused. I'm in support of SB 1033. Thank you.
Thank you. Nobody else in support? Do we have witnesses in opposition? Thank you, and if you could state your name and who you're working for.
Certainly. Good afternoon. Alicia Sanchez with the California Medical Association. We're in strong opposition to this proposal. And first, I would like to note that the question at hand, as the author spoke to earlier, is whether patients should be provided information of probation. The testimony that we heard really seems to suggest that there are concerns about the actual action taken by the medical board. That is a separate question. The medical board has authority to discipline physicians. One of those actions is probation, which allows the licensee to continue practice. This proposal is essentially a de facto suspension because it would severely impact the physician's ability to practice. And we have to oppose that. Physicians are afforded due process, and we need to continue that. We need to continue to allow the board to take actions as they see appropriate. Additionally, the proponents spoke to the fact that the information that's currently available is not easily accessible. In the Consumer Reports document that came out earlier this month, it in fact notes that California is the most actually accessible websites in the country. So it boggles the mind a little to understand how they would come to that conclusion for the report and yet then continue to find it inaccessible now. One of the underlying assumptions of the proponents is that probation is only a slap on the wrist. We disagree with this interpretation. Probation comes with significant impacts for a physician, from potentially losing privileges that they have to practice in facilities, losing contracts with payers, and making it more difficult for them to get privileges and patients in the future. The compounded impact of this proposal, along with that, is the inability to practice. There are numerous other complications that arise from the proposal. The summary that's required to be produced by the board is bound to create opportunities for disagreement between the physician and the medical board about what is to be incorporated into that summary. The proponents complain that consumers must contend with legalese when looking up information about a licensee. That's in part because these documents are part of a legal proceeding. And once you start trying to parse that information, you're putting both parties in the position of making interpretations. This is important to note in particular because so many of the cases that the medical board takes action on are stipulated settlements. There's not been a trier of fact. The physician and medical board negotiate an outcome. And so what you're requiring the physician to provide to the patient are the allegations, the charges. The exemption of the notification provided by the bill is essentially unworkable and will put patients at risk, but it acknowledges that there are situations in which this notification is not acceptable because of emergency situations. I mean, it acknowledges that it impedes practice. The bill will discourage the disposition of an accusation through settlement, because a physician who believes that they are being falsely accused will have little incentive to settle the case, and instead will pursue through the hearing process, going all the way through adjudication. That will increase the number of cases that go to hearing. It will drive up the amount of time for which enforcement actions are dispensed with, and that isn't good ultimately for anyone. CMA is disappointed that the Medical Board Task Force on Increasing Public Outreach was not allowed to complete its work. It sends a clear message to us that there's only one viable option from the proponent's perspective, and we strongly oppose it. CMA urges your no vote today.